Good morning, everybody. Welcome to Mediation Week and this talk on mediation arbitration. And we're particularly going to be looking at the options that might arise when people get stuck in mediation. And indeed, what a lot of people are going to talk about here is also relevant in a collaborative case too. What we're going to do is explore what you do need when you get stuck in a mediation, and in particular, what information and incentives can be given to move it along. With me is Rhys Taylor from 36 Family. He is a mediator. He is a very frequent early neutral evaluator and evaluator in private FDRs. But also he's a qualified arbitrator who sits regularly in that position. He sees it from all sides because he's an advocate in court and a recorder with some very entertaining published judgments recently, particularly in the Financial Remedies Journal. Only last month he was appointed as a Deputy High Court Judge, and he's insisted that throughout this presentation I refer to him as my Lord. I'm David Emerson. I'm a mediator. Most of my work is mediation, although I'm also a collaborative practitioner, and I sit as a deputy district judge with a certificate in financial remedy and private law children. So if we now sort of think of the situations where we can get stuck, Rhys, what sort of situations can they be?
Well, my observation, particularly so far as arbitration goes, is that sometimes you can just see why the parties just can't sort this out themselves. And so that there's just an agonizing decision to be made, and there's two points of view, and they're two genuine points of view colliding. And quite often that's in circumstances where either a lot of money turns on it or there's not enough money for both parties. And so the competing points of view are really important. You also have situations where there may be a binary outcome for something. So, I'm thinking perhaps does a third party own an interest in the family home? Does a third party are they entitled to the repayment of a very substantial loan as a matter of law? And so in the dispute resolution context, we're all very adept these days at trying to find the middle ground. And there are many ways in which when the cake is being cut, or when one is looking at quantum or term of maintenance, those kinds of things, it's possible to find a compromise. But just sometimes they're just really difficult questions that are agonizingly difficult to answer.
I mean, it applies equally in children too, doesn't it? Because you might be stuck about the parties agree that there's fairly significant sharing of time, but is it a 3-4 arrangement? Is it 7 days, or is it 8 days with one and 6 with the other? Those.
Yes, and also in the children context, there may be a dispute about where a child should go to school, or for instance, an internal relocation that's going to have profound implications for the family. And there are, forceful and genuinely held views on, and legitimately genuinely held views on either side of the argument.
Yeah, that's true. It isn't necessarily one person or both of them being intransigent or difficult, because there can be finely balanced cases that need that sort of guidance. So what are the types of options that would be available when you get a bit stuck like that?
Well, there are there are two options that we're talking about today. There's a neutral evaluation where a, a neutral person will give a non-binding view, and sometimes um, having a third party come in who doesn't have any skin in the game and can just say, well, this is how it looks to me, and from my experience, this is what I think would happen in court, is enough to, much to the frustration of the party's lawyers, no doubt, who have probably been advising their clients in any event, but having a third party step in sometimes helps. So neutral evaluation is one way of busting those on passes on the road. And then there's also arbitration, but arbitration is different. It's in as much as the way in which it's conducted and the way in which it's set up, and we'll come on to the procedure for that shortly, is that the arbitrator will deliver a decision which will be binding unless it's completely wrong and could be appealed as a matter of law.
So if you go to arbitration and the arbitrator makes an award, can one party say, well, I'm sorry, but I don't agree with that. I'm not going to follow that?
Generally, no. And so in commercial arbitration, the answer is absolutely no. And the Arbitration Act 1996 provides the narrowest of opportunities for decisions to be challenged. In the family context, we do things differently, don't we? And we're a bit of an island, even though we try to say that we're not. And there's been authorities over the last few years, the leading one being the case of Haley, which has come to it that the arbitrator under the IFLA arbitration scheme effectively is like a first instance judge whose decision will be binding, providing it can't be shown to be plainly wrong. And so in the same way as a decision before a district judge will be binding, unless they've got it completely wrong, arbitration will be binding unless there's, some really erroneous decision.
Is it exactly the same test that an appeal judge would be looking at?
Yes, it is. I mean, the procedure is slightly different because, of course, there hasn't been a first instance decision, so it's not an appeal under Part 30 of the Family Procedure Rules. It would be argued about under a notice to show cause procedure, but the judge would be asking whether or not the arbitrator had got it wrong as a matter of law. And there's all the points about the first instance judge being best placed to assess the people in the room, having a wide discretion, not being obliged to deal with absolutely every single point in the case, although arbitration awards are very thorough. And so it's only when you're completely outside of the discretionary bracket would an appeal be successful. And one sees in the number of cases which have come before the courts about an arbitral award, it's absolutely vanishingly small when on the occasions when they're set aside.
So, and how is it enforced? How's the award enforced?
Okay, so the parties, when they enter into an arbitration, sign an ARB1 form. There's a children form and there's a money form. And they sign solemn declarations when they sign that. They intend to be bound by it. Now, of course, in the family context, we don't have binding contracts, but the courts would endorse the award. And so typically what I would do is I would give a reasoned, in the arbitration context, they're called awards, but it looks like a judgment. You deliver your award, and at the end of your award, you would probably spend the last couple of paragraphs giving a strong steer and a comprehensive steer as to what you would expect to see in an order. It then falls to the parties to draft an order and to propound that order before the court. And so they'd go before the court and they'd say, will you approve this order, please? It was made pursuant to an arbitral decision which is attached here too. And in many cases, the parties will just agree, and that will be by consent. If one party is hugely disappointed and wants to challenge, they can do so under the notice to show cause procedure, and then the judge will have to decide whether or not the arbitrator can be appealed, essentially, and then an order of the court is put into place, and it's the order of the court finally which then provides the enforcement mechanism for the arbitral award. An arbitrator doesn't have any coercive powers. It's not a formal part of the court system, and it relies on an order of the court ultimately. But the powers that be in the family justice system have been extremely sympathetic and supportive of this arbitral system. They're keen to see cases being resolved that way because it's less cases for them to resolve.
And just sort of following on, if there's a difference between the parties post-award about the wording of the consent order, can the arbitrator help out there in practical terms?
So the rule is, the official rule is this, that once you have delivered an award, the arbitrator's role has come to an end. In old-fashioned speak, they're functus officio. But what I tend to say in my awards is that if the parties want me to help out with perfecting the award, I'm available to do so, and many people do that. But if both parties don't agree to me helping out with perfecting the award, if one party is so disappointed with the outcome they never want to hear from me again, then it then falls to the propounding party to draft up the order that's reflective of the award and then get the court to order it. But you know, the award is an extremely comprehensive document, and mindful of the fact that there may be continuing argument notwithstanding an award, I'm extremely clear, and arbitral colleagues will be extremely clear in their award as to what they expect to see in the order. I mean, the one leaves very little space for debate.
I mean, do you effectively use the precedents to say what in summary what?
No, because I'm not the court. And so I'm not drafting a court order, but of course I know, because my day job is doing this as a barrister. I know full well what I expect to see in an order. So all of those, all of the points that one knows arises and the arguments that are come to bear, one covers it all off in a sort of in a short narrative saying, well, look, this is what I expect to see in the order. Now go away and draft it. So I'd like to leave the parties in absolutely no doubt whatsoever what the order should look like.
Okay. So I've finished with the ending, but going back a bit to the beginning, can you explain what the difference is between an arbitration process and a court process in terms of how the case is prepared and how the parties and the advocates interact? But before you do so, I forgot to say, you're more than welcome, listeners and viewers, to join in the chat and ask questions or make points. We'll be picking up as we go along. So please join in that way.
Okay. So in many respects, the arbitral process is very similar to the court process, in as much as there will need to be an agreed amount of disclosure. There will then need to be, in the usual course, a hearing if there's a factual dispute, and then a determination. But there can be flex. I did quite a complicated arbitration last year where the parties agreed disclosure was on an Excel document. They'd agreed their disclosure and they said we each side agrees that we're not using Form Es. That is what we say the assets are, and we want you to proceed on that basis. And I was able to do so. If one party said, well, no, I'm not happy with that, then I would have required Form Es. And if there's no factual dispute between the parties, it would be possible to have a determination on the papers. But quite often, there is a factual dispute that needs a resolution before you can then make a decision. And my experience is that it's the factual disputes between the parties that are quite often what's driving why they can't resolve their issues. The other thing that I would mention in terms of difference between a court hearing and an arbitration is that, generally speaking, a court hearing is dealing with all matters arising, whereas it is possible in some circumstances to put to an arbitrator, we would like you to deal with this one issue, and then the arbitrator will do that if they consider it appropriate to do so.
What might be an example of that?
So there could be a host of single issues that the arbitrator might be asked to adjudicate upon, but the arbitrators having in the back of their mind at all times, this has to be turned into a court order. And so you couldn't midway through a mediation where there's still lots of things up in the air, come to the arbitrator to say, well, can you please make a binding decision about the quantum of maintenance? Because, well, how much capital is being divided? And I really need to know what the capital position is globally before one can then look at maintenance. But if, for instance, in mediation, the parties had been able to agree the capital division, the pensions, and the only issue remaining was the quantum of maintenance, then I would be able to, if you like, put that last piece of the jigsaw puzzle into the global picture. There may be some instances where you can deal with a single issue. I mentioned earlier those sort of binary questions. Does Granny own an interest in the house or something like that, which is a standalone question. That might be dealt with by way of an arbitration, and also directions could be dealt with by way. So, for instance, there may be a dispute between the parties as to whether or not there needs to be a single joint expert to value a business. Is the mediation to proceed on the basis of the figures from the family accountant, or is it necessary to have a single joint expert? And I could deal with that kind of question as well. So it all depends on the circumstances, but the touchstone is this an order? Is this an award that an arbitrator can make, which could be converted into a court order? The arbitrator can't just shout into the wilderness. It needs to be something that would form part of a binding set of propositions that went before the court.
Yeah. Okay, so arbitration is one of the non-court options, and of course, this is Mediation Week, and mediation is promoted very much because it's supposed to enable the parties to make a decision and take some of the heat out of the situation. That's the same with collaborative. But arbitration seems very much like the court process, and although it's called non-court, it could just be the same atmosphere, the same tactics that you would get in a court process. Can there be differences when conducting an arbitration?
I mean, it depends. Typically, an arbitration will take place in a chambers dispute resolution suite. Most leading family chambers have one now, or maybe in a solicitor's boardroom office, that kind of room. And I make a point in my arbitration saying, look, thank you for asking me to be here today. I hope I'm able to sort this out for you. We're in a relatively small room. This is not a courtroom. I'm going to ask everyone to be kind and courteous to one another. Although you've asked me to resolve this for you as if I was a judge, today I'm not actually a judge. So you don't need to call me judge. I'm only here because you've asked me to be here. And so I think just the kind of the way in which people deal with it, and arbitration's been around for over 10 years now in the family context, and I think we've all learnt tricks on how to put everyone at ease and to make it a more accessible and gentler process than being in court. It's very rare that an arbitrator is going to be at the end of his or her patience. You're paid to be there, and you're paid to provide a quality service. But there may have to be cross-examination, and there have to be submissions, and difficult things may need to be said. And so to that extent, it can resemble a court hearing.
Thank you for the questions you're posting. We are going to deal with them. We're going to make a bit more progress with questioning Reese, because I think some of the answers will emerge there. So you're stuck in your mediation. You're stuck, and you're lucky you've got lawyers. The mediator might say, well, these are the things you can do. You can do early neutral evaluation, which I know we're going to turn to in a minute, and you discuss the option for arbitration, and the parties decide they want to do arbitration. How does it go forward from there? How do you choose your arbitrator? Who puts together the instructions? How do you agree what needs to be decided?
Yeah, so a couple of points here. Typically, the way in which an arbitrator is chosen is that one side will put forward usually 3, but maybe 5 arbitrators, and then the other one will pick one from that list. I think that the choosing of the arbitrator is, I think, become easier. I think that practice has sort of developed now. And in any event, there are a number of people who have been doing this for a number of years now. So there's a sort of a fairly obvious pool that one can turn to. So that's in terms of selection, relatively straightforward. It might just come down to availability.
Is there a list anywhere?
Yes. So the IFLA website has a list of all qualified arbitrators, and all leading chambers have a dispute resolution page now, and you can go and see who's qualified as arbitrator. People aren't holding back about it, and you can find out who's doing it, or just phone around chambers and say, right, who's available. I picked an arbitration up in November. The court service had bounced a hearing which had been waiting many months, a couple of days before the hearing, and so I happened to be the person who was available. It might be availability, or it might, people might really want X or really want Y, or they may choose an arbitrator for their noted expertise in a particular area. Procedurally, I think the trick for me comes down to the wording in the ARB form that gets filled out, because the arbitrator is only there by the party's invitation. They're not imposed. The arbitrator isn't imposed on the parties like a judge is. They're there at invitation, and so the invitation needs to be wide enough. If you were to fill out in the financial remedies context, fill out an arbitration form saying, would you please sort out how to divide the assets, for instance, arguably that's not wide enough to deal with maintenance or costs. And so quite often an arbitrator will be very happy to just give a once over of the draft ARB1 just to check it's wide enough. I tend to subscribe to the view that less is more, and that if you say the arbitrator is invited to determine the dispute arising between the parties that was in Portsmouth County Court under number 1234, that would be enough. Or you might say the arbitrator is invited, if there are no proceedings, the arbitrator is invited to determine all issues as if a application had been made to court, and then the widest range of powers are available to the arbitrator, other than coercive powers. An arbitrator can't make an injunction, can't accept an undertaking, and so if those points.
What happens if one party refuses to file their statement in an arbitration? What?
Wow, that's interesting. So usually, if people have been orderly enough in their disagreement to agree to a to an arbitration, they're normally, the kinds of people who cooperate with the directions. But I have had experience of people who've not complied. I had one case where the ARB1 was signed, and then as soon as the ARB1 was signed, the husband sacked his solicitor, and then was very difficult. But I'd been commanded by the ARB1 to deliver an award, and so that's what I intended to do. And I needed a case management hearing, and so I communicated with both parties saying that I'd like to hold a case management hearing. He was difficult about that, and so I gave him numerous options. I also told him that if there were any difficulties with health or special measures or anything like that, just to let me know. And I gave him absolutely no excuse at all as to why he couldn't attend my convened case management hearing. He didn't attend. And so I made my case management directions in a Zoom session, which I recorded. I even reserved costs against him. What a fair-minded tribunal, eh? And then afterwards, I sent him a copy of the Zoom link so that he could see that we were going to proceed, and we were going to determine this, just like a judge would determine it if somebody wasn't cooperating. And then he actually, he then re-instructed a solicitor and got back on board. And so the command in the ARB1 is for the arbitrator to deliver an award, and that's what they'll do. And if someone doesn't cooperate, the arbitrator will find a way to drive things forward, and that may be by drawing adverse inferences or just accepting the evidence of the other side. So there are ways and means.
So could a mediator help with the selection of an arbitrator, and could a mediator help with the drafting of the ARB1, or is that principally the role for the solicitors? And I know some of the questions are about how do we do this without solicitors, and we are going to.
Yeah. So my experience over several years now is that it's uncommon for there to be a litigant in person doing an arbitration. They do pop up from time to time, but it's more difficult to manage. Usually they have a lawyer, and so I'm not saying a mediator doesn't have a role in signposting if you've really hit the rocks on something, or it may be that you've agreed 95% of what needs to be resolved, but it's that last 5% that needs resolving. And then I think probably that the best thing for a mediator to do would be to say to the parties, well, if you have lawyers, you might want to think about this. I suppose if they don't have lawyers, and you can find an arbitrator who is willing to deal with an arbitration with litigants in person on both sides, and no doubt there will be arbitrators out there who will do that, then the key tip is that the ARB one is less is more, and you just make the jurisdiction as wide as possible. Dear arbitrator, please resolve everything. Is the sort of is the ask. Don't overcomplicate it.
Yeah, and may I say that that is really no difference to most DJs and deputy DJs sitting around the country dealing with unrepresented parties. They
Yes.
have to grapple with those
Yes.
situations of
Yes.
unauthorized disclosure and so forth.
Yes.
So
Yeah,
there's
absolutely. So
no
it can be
reason why.
done. It can be done.
Yeah. And how much does it cost? I mean, obviously, Reece, you're so high end, it's just not. You look at that quality of that suit. But I mean, how? I mean, funny enough, I was up revising our firm's estimates, and for this type of thing, and you can get an arbitrator for as little as £1,500 to £2,000, particularly people who aren't doing it on a regular basis, who are looking to get experience. I mean, because they haven't done very many arbitrations, but they are very experienced lawyers, and you're probably getting good value
Yeah,
paid.
so I think what I would say is this: it's a competitive market, it's a new market, and there's lots of people who've qualified over the last 10 years who have only done a few and are keen to do more, and so I think there is a range. And and also in part it's to do with the complexity. If it's a chattels only dispute, who gets to keep the dog, for instance, hugely emotional question for the parties, that they might not be, that kind of thing might be at the lower end. But if you're asking for an arbitration for 5 days with 5,000 pages, the fee goes up accordingly. And so it's not wholly dissimilar, I think, to the kinds of fees you pay for barristers, and you can sort of have a brief and then subsequent days on a refresher basis, perhaps a little bit lighter than pure barrister fees.
And that's because the barristers who prepare the case tend to go into the reading, the preparation in greater detail than in fact the arbitrator needs to, because the arbitrator is relying upon the advocates to
Yeah.
present
Yeah,
them.
and so I think actually you may find that those litigant in person arbitrations we're talking about, someone willing to do that might say, well, I'm going to bear in mind I'm going to be hand holding the disclosure process and the organization of everything, and that might increase fees.
So arbitration is not a cheap option for resolving
No,
anything.
it's not. No, I mean, if you go to court, you've paid your court fee, and the judge then is for free. So it is more expensive. I think, I mean, this sounds a bit trite, but many of you on the call will have been involved in family litigation or witnessed family litigation. And if you have several months before a court hearing, life doesn't sit still, does it? Things happen. The litigation takes on a life of its own, and just the fact that solicitors are instructed over several months leads to increased fees. Whereas an arbitration, you can get to the finish line more quickly. And so, yeah, there's no pretending that it's not more expensive, but in the global spend of a substantial dispute, it might be a proportionate spend.
I mean, the general feeling amongst colleagues in dispute resolution committee is that if you're contrasting litigation with arbitration, arbitration tends to come out about 2/3 of the costs of the litigation, but it's still expensive. So as a mediator, you would be saying to the clients who are stuck, come on now, let's have another go at this rather than committing themselves. So can we talk now about early neutral evaluation, because that is a different option and it has some similarities with arbitration, but a lot of crucial differences. Would you like to explain what early neutral evaluation is, and in particular what a private FDR
Yeah.
is?
So I prefer, if I may, to call it neutral evaluation, because you could have an evaluation at any point during the process, but we normally think of it as at the start of the process. But yes, either early or neutral evaluation. Typically, you would have an FDR style hearing. I think most people on the call would recognize what an FDR style hearing is. In summary, there will be a tribunal. There will be advocates. The advocates will provide summary notes setting out their client's best points. There will then be a shortish hearing where we're not resolving disputes of fact, but the case is being pitched and spun at its highest on either side. And that is, the submissions may take half an hour, they may take an hour, they may take 2 hours. On either side, it depends on how complicated the case is. The tribunal then takes, a break of, I don't know, maybe somewhere between 20 minutes and an hour to gather their thoughts, and they will then deliver an indication. There are different styles of delivering an indication, but I think most tribunals would deliver, at the very least, an Excel document showing their numerical thinking in the financial context. And many will also provide a summary document dealing with the key contentions. Some people go on and deliver a sort of a beautiful essay that's almost akin to a court judgment. But of course, the time taken in doing that is time taken away from the parties being able to negotiate. So I think where we've got to is that it's a sort of quick and dirty written document that just summarizes the key points so that people have a durable record of what was said, and an explanation of the figures. That's also delivered orally, and so typically parties come back in after submissions have been given. The tribunal will deliver their view and encourage the parties just to think about the good sense in resolving their issues, and then give a view on what the rival contentions are. And
So
it's non-binding, and it's not going before a court. It's without prejudice, and it's confidential. And so, unlike the arbitrator, who is always thinking about the judge on his shoulder, who he's going to have to get this past, the arbitrator is giving a quick and summary view as to how it seems to them.
So it's much more flexible than arbitration, even though it doesn't give the answer to the parties.
I mean, it's flex. Yes, I mean, I suppose. I've done neutral evaluations with very sparse documents, and so there's one I can think of in particular, that was a property related one that essentially I had a letter before claim, an RX1, a letter in response, and the land registry document. I mean, it was really, really basic stuff. And I said, look, you've given me, very limited information to go on, and so my indication is going to have to be correspondingly limited. But from these documents, I can tell you what it looks like to me, such as it is. and it resolved on that. And so you can have a an evaluation light, or you could have gathered a lot more documentation. There was a view taken years ago that you couldn't have an FDR if there are factual disputes, substantial disputes, say an argument as to whether, Granny has an interest in the house or something like that. I think just the sheer cost of litigation has driven people the other way now. And quite often in an evaluation, you're saying, well, I'm not dealing with findings of fact today, and so litigation gives a definitive answer according to law, but this is how it seems to me. And if the facts swung this way, my answer would be this. If the facts swung that way, my answer would be that. And so you've got a range of possible outcomes there. Sometimes you can be definite, sometimes you can just sort of say, well, it rather depends on how it goes in court, but these are the parameters and these are the things that I've got in mind.
And where would you find an early neutral evaluator? Arbitration, you say you go to the IFLA website and look at the list. Where do you find?
Well, again, all leading chambers have a dispute resolution page. Many solicitors will have a dispute resolution page on their website. The Financial Remedies Journal, which I commend to everyone, given that I'm the editor of it, has a private FDR tab where those who are available to do private FDRs have provided their contact details. So that's a useful place to go. And the thinking behind that, in case anyone is interested, is that there was a feeling some years ago that this work, which is nice work if you can get it, if I can put it that way, there was a feeling that it was going to the same white men over and over again. And so Simon Bruce drew up a list of all people who said they wanted to be available to do private FDRs or did private FDRs, with a view to encouraging diversity. But you needed to know that Simon Bruce had done that list, and you needed to know how to get it. And so really what the Financial Remedies Journal did was to take his idea and put it into a publicly available format, so that you can just scroll down the list and you can see who's there, and it's it's gloriously diverse in the options of people and the prices and the options and expertise that's available.
Okay, so coming back to the role of the mediator in early neutral evaluation, it seems to me that early neutral evaluation is much more flexible, and it isn't quite the straitjacket that arbitration is, and therefore the mediator can take a greater role in the preparation of the information and documentation to go to the early neutral evaluator, because they're in a sense they're almost ideally placed to put the neutral perspective
Yes.
in summary, and obviously in conjunction with the parties and their lawyers who will want to ensure their points are put. You could probably get there a lot more efficiently and cheaper with the mediator
Yes, quite
at the
possibly.
helm.
Quite possibly. So, of course, it is, it would be usual that the mediator would have managed a disclosure process and probably has a working schedule of assets in play, and will have summoned the facts of the issues between the parties in a way that has identified that which is agreed and that which is not agreed. And so I think the opportunity for a mediator to tag team, as it were, with an evaluator that's more of an option than with an arbitrator.
And I mean, I did I was a mediator in a case where people got stuck, and it was decided that we would go to early neutral evaluation. And Philip Waller, who used to be the senior judge at the principal registry, was our tribunal. Sarah Manning, who I think is on listening to this, was one of the solicitors. And we collaboratively prepared the documents with me taking the lead. And I asked whether it was a good idea for me to attend the evaluation and help with the negotiations. And the parties were happy with that, even though it sort of bumped up the costs. And Philip Waller was very pleased too. And the way that worked is that in the morning he gave his evaluation, which was, as you'd expect, very comprehensive and very precise. And then I went off and negotiated. It was all but done by Zoom, and mediated that process into a settlement. And that answers, I think, one of the questions that was put in the chat. But it's difficult to see how the mediator would play any role in the arbitration, because there is no discussion after the award. And that,
No, I mean the process of arbitration is trying to persuade the arbitrator and informing the arbitrator of all of the relevant facts and issues for the arbitrator to deliver an award. You're not asking the parties to do their own deal. You're asking the arbitrator to serve up a solution because the parties can't. Whereas in the neutral evaluation context, private FDR context, then I think the mediator does have much more options. Now, as it happens, the very interesting description you've given of what you've done with Philip Waller, I think doesn't happen enough. I think mediators should be, come forward and do those kinds of things a bit more often, because of course, it's all good and well, giving the indication, and that myth busts for some people, but of course the tribunal is generally a stranger. What do they know about the case? They've just come into it, had the papers yesterday, delivering a view now. Whereas the mediator's sort of been building up that relationship over weeks or possibly even months in some instances, and so is an honest broker. And I think also, if you're coming out of mediation for a discrete issue which you want to put to an evaluator, then having the mediator in the room hearing what is said makes it far harder for there to be wiggle room afterwards. And there isn't the same problem, or not to such an extent, in a neutral evaluation, about the arbitrator's problem that they're thinking, well, how is this going to be enforced in court? An evaluator can paint more widely, can sort of say, well, if the capital was divided in this way, I think my answer in respect of maintenance would be this. If the capital was divided in this other way, I think my answer would be slightly different. And so you can paint more broadly, but having the mediator there as a figure who is trusted and respected by the parties, I think is a great idea.
okay, just looking at the chat, someone says, have you ever come into a collab to do an early neutral evaluation? Well, I have in a collaborative light, and I do know people who collaborate on a regular basis have, when they've got stuck, they've appreciated the assistance that a mediator has given. So it certainly has happened. I don't think it's regular. Reese, one for you. What's the difference between an early neutral evaluation and a private FDR, and what's I'm now going to add a neutral evaluation because you've changed
Yeah.
the,
So
the acronyms again.
I think neutral evaluation is the really generic name. A private FDR or an FDR is a financial dispute resolution hearing. So it is a subspecies of a neutral evaluation in the financial context. But you could, and they're rarer, but you could have a valuation in a children context.
So not much really. Here's another one. Do you need a legal background to qualify as a family arbitrator? And elsewhere, there was a question of what's the process of qualifying as an
Yes. So
arbitrator?
to qualify as an arbitrator, you need to become a member of the Chartered Institute of Arbitrators, and you do that by going on a course put on by the Institute of Family Law Arbitrators. It's quite an exacting course. You have to write an award, pass an exam. It's not a given that you will pass. There's lots of people who don't pass first time. And you also need a judicial reference. I think you need two judicial references. So you can't just, you need a level of experience dealing with financial matters or children matters if you're applying for the children one before you can get onto the course.
Okay, here's one from Lynn Ayrton, who sits as an arbitrator and
Hello,
says
Lynn.
that whilst I agree with Rees that a widely worded R1 is beneficial, likewise, one of the great advantages for the parties moving from mediation to arbitration is to note on the R1 issues that have been agreed, for example, housing. So how does the sort of the privileged without prejudice part of a mediation, how do you deal with that when you...
So I think, so obviously the arbitrator is not allowed to see the privileged stuff, but what you can do, I totally agree with Lynn, that if there are things which are agreed, set them out, give the arbitrator wide powers, but tell the arbitrator what's already agreed on an open basis that they don't need to resolve.
Okay,
And
here's
quite
another
often the statement of issues will deal with that.
Here's another one from Deborah saying there's a feeling that arbitrators are a little bit softer on issues such as serial non-disclosures and...
I don't necessarily disagree. I don't agree. I think one of the issues is that the non-disclosures are less likely to be in arbitration because you've each got to agree to be there in the first place, and people who want to disobey the law might not sign up in the first place. But certainly, I can think of a number of instances where I've been called upon to make inferences and findings of fact about what hasn't been disclosed and have not held back from doing so.
Yeah. Do barristers attend the arbitration with solicitors? Well, generally there's an advocate,
Yes.
which could be a solicitor or a barrister, and solicitors usually attend, but there can be a cost issue and they don't need to. And again, cost ballpark, is there a cost ballpark? Well, it really is. You can do these things.
I would say the going rate for an arbitrator is probably somewhere between three and a half and £6,000. Finger in the air. There's more expensive ones out there and there are cheaper ones out there, but I would say the overwhelming range falls within the 3.5 to 6, and the parties would pay half each.
And the same evaluator, sorry, the same arbitrator doing the evaluation, that their fee might be cheaper for doing the evaluation because they do you think, or is it broadly the same?
I would say not dissimilar actually.
Yeah.
I think for the work involved in a 1 day arbitration, I think fees. I mean, I'm just putting my finger in the air here. My sense of things, fees in the arbitration context are a bit keener.
Yeah.
Right, we're being told. I think our time's up, David.
Is it? Okay. Well, Paul Linsel, I'm very sorry, weren't going to get you could be parachuted in as as an arbitrator, but only on isolated, discrete issues. Well, thank you all very much. I'm sorry we didn't get back to all of the questions. We'll try and answer them. In the slides and the documents that we've sent out, there is contact details, so you can always contact either Rees or I if you've got...
There's also a website, familyarbitrator.com, which has some useful materials in relation to family arbitration.
Thank you all very much. Good morning.
Thank you.